Morning, Your Honor.
The first case to come before the court is State versus Taylor, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes if you so choose. Just please let me know, and I'll try to keep your time for you. Help you out.
Thank you, Your Honor.
And we're ready to proceed when you are.
Morning, Your Honor, and may it please the court. John Toth, counsel for Anthony Taylor, appointed from the trial court. Anthony was indicted with a one-count indictment for unlawful sexual conduct with a minor. It happened, the alleged incident happened about a month after he turned 18, and the alleged victim was 13, about a month away from turning 14. Went through standard motion practice. There was a jury waiver, and it was a bench trial to the court. I filed one assignment of error, and that was a manifest weight argument. Really, it's going to cut to the issue of State v. Tompkins, where I know this court and courts across the state of Ohio always cite to controverted testimony by itself will not be a basis of reversal on appeal. So if the trial court or the jury decided to believe some witnesses over others, it's not the appellate court's position to reverse. Really, when it came down to this case, my assignment of error was based off of text messages alongside of the controverted testimony, trying to get above that standard of strictly 4 witnesses said this, 1 witness said this. In this case, it was a 14-year-old's mother playing on her cell phone, saw Facebook messages between the victim in this case and Mr. Taylor that were highly suggestive and sexual in nature. Kind of devolved where this is one of those family situations where the defendant isn't related to the victim, parents are friends, and the defendant's basically living at the victim's house for weeks at a time before he's the age of 18. At the age of 18, it's pretty uncontroverted between the appellant and the victim that there was sexual contact and conduct over an extended amount of time. The victim testified that they had sexual intercourse twice. The defendant made admissions to Lorain Police Department that they had sexual intercourse. What it came down to was the dates. So the victim used a date that she had been cooking with another sibling. There was a fire at their house. They had to leave. That date was able to be documented to January 10th. The defendant brought 3-4 witnesses that it was a relative's birthday at that time. All of them testified. The victim wasn't at the house that day. Couldn't have happened. What it really, the trial issue was, well, the trial strategy was to try and paint the offense date happening before December 18th of the year previously, because then he would have been a delinquent, would have been a delinquency proceeding. Or, on the flip side, trying to get the testimony to say it happened in February, when the victim was up to the age of 14. It didn't really work out. There was not a lot of appellate issues when it came to sufficiency. There were allegations, they were there. I don't see a great appellate assignment of error. What I do have is that manifest weight. So we do have controverted testimony, and the evidence I'm proffering is more than just testimony, as there are some text messages that refer to sexual contact on December 8th, which would have been when the defendant was a delinquent at the time.
Would that be any type of defense or mitigating factor in regard to if there were sexual intercourse that occurred after he turned 18 and before she turned 14?
After he, well, not really.
So I was going to say, because the whole point is, even if they have sexual relations prior to him turning 18, there was a 3-month period that...
Correct, and she still would have been 4 years younger, and you can't really
She's still been 13.
parse around that, but when I'm looking through the transcript, there's not a lot. I mean, there was a little bit of truth of the matter asserted testimony that was brought up that's not going to really matter in this case because it was a jury waiver. So the trial court would be able to parse that information out. And to be frank, this is probably the only time I ever filed one assignment of error. I didn't think it was appropriate for Bernie Andrews' brief because it was a trial that was controverted testimony. But I guess that's my assignment of error. That's what I'm proposing is that this meets that threshold in State v. Tompkins where we're not just looking at evidence. Now we have some sort of evidence that was proffered, and I believe I attached it to my assignment of error. It was a text message from December 8th. I wish we could kick it like we did sometime in the past, which would have shown an actual evidentiary corroboration that the date of the offense was before the appellant's 18th birthday.
What his testimony that he wasn't sure what that text message was referring to? His initial testimony.
Yes.
He didn't remember. It was a long time ago. I don't remember.
Well, I mean, this is one of those where it was actually kind of gave you a headache when you're reading. This is really the appellant and the victim because there was probably 5 or 6 times where there's pretty effective impeachment of both of them. So you had a lot of flip-flopping where, no, I didn't really know what it was. Yeah, I didn't know what it was. It couldn't have happened on this date. It was before this date. Maybe going up back into October. And yes, I mean, the gist of it is he didn't know what that was referring to, but the testimony that followed that kind of inferred that when he was spending the night at that house, they were canoodling. It never really got out that there was sexual intercourse, but they would, trying to think of a proper word, never. Yes. Yeah, I mean, and that's basically what it comes down to, but the victim testified that the first time they actually had intercourse with him was at that January 10th. And that is my assignment of error. Thank you.
The state will have 15 minutes, and I apologize to everybody before we begin. I'm just so used to having Judge Cannon around because he's visited with us before that I forgot to introduce him and tell everybody we're happy to have him here with us. He's from the 11th District, and thank you for filling in today.
Good morning, thank you. Your Honors, may it please the Court, Mary Solansko on behalf of Appellee the State of Ohio. I'm at a disadvantage this morning. I have shingles and I'm trying not to touch anything that other people have to touch, so if I put my hands in my pocket, please forgive me.
Oh, no. We just hope you get better.
Thank you. This case really comes down to a credibility issue. You have the victim and then you have the defendant testifying, no, the sex occurred after I was, or before I was 18, and the victim was very clear. She said the first incident was January 10th, and the defendant put on a lot of alibi witness from his family. It was all very similar testimony, very, they each followed exactly what everyone else said, and they said there was a party for Mom's birthday, and she wasn't there. And she said, well, I had sex with him on January 10th at his house. But what she also said is, I had sex with him twice. The first time was January 10th, and the second time was before my birthday, February 7th, which is when she would have turned 14. So sometime in the month, late January to early February was the second time that she had sex with him. And the reason I bring that up is because when you look at the record in this case, the indictment actually says on or about January 10th. And I've cited case law in my brief that says that the exact date of an offense is not an element, and especially where the state alleges that something occurred on or about, there's quite a bit of case law that says that as that date is not required to be specifically proven, if it's within a reasonably close period of time. So what you're talking about is anytime reasonably close to January 10th, the victim could not say exactly when the second incident was, other than it was before her birthday. And there was nothing really impeaching that other than the defendant's own self-serving testimony that he did admit to having sex with her on more than one occasion, but again, he always stuck with it happened maybe sometime back in October. And as your honors have pointed out, the text message of December 8th really does not contradict the victim, and it isn't evidence that supports the defendant's innocence of the January 10th incident in this case, because what the victim said in the December 8th text is that they needed to kick it like they had before. She testified at trial that referred to kissing. We had engaged in kissing, which is a natural progression when you have a relationship like this, that there may be some of that going on. And she said that's all that had occurred at that point. And even the defendant's testimony was it could have been about sex. He didn't know for sure what it was about, but he says it could have been about sex. And again, his testimony is very self-serving, and you have a young lady in this case who, you know, clearly the evidence shows that there was a sexual relationship with the defendant, and she came into court and testified about that. Her mom is the one that discovered the Facebook text messages on her phone and then contacted the police, and she was very consistent with them and with her testimony at trial that this had occurred on 2 occasions. She identified the text messages. The court will have those, and I do refer to them in my brief and to the exact page numbers of the exhibit, so I hope that will help the court in reaching a decision today. But I submit that when the testimony is simply contradicted, you have to look at who's doing the contradicting. In this case, we have the defendant and his family members. And all they're contradicting is that one specific date. They're saying there was a party at our house and she wasn't here. But they don't give a time frame of the day. She doesn't say what time of day. So it certainly could have been something where, you know, she'd been there earlier in the day. They'd had sex, other people weren't around, the party hadn't started. There was not testimony that this began like at, you know, 8 o'clock in the morning and went until midnight on January 10th. So I don't think that you have to completely disregard her testimony that it occurred on the 10th, because I don't think it's a complete contradiction. They're saying she wasn't at this party, but without more to identify exactly the parameters of the party and what time she was saying she had sex, I don't think that evidence weighs in favor of the defendant in this case. I think the evidence in this case supports what the victim testified to. The indictment, when you look at the record, and the specific reference was May 14th. Indictment was filed in this case, and when you look at that, it says on or about January 10th. And there's case law that I've cited in my brief, State versus Miller out of, I believe, the 5th District, that says that the exact date is not required to be proven. And then the fact that the defendant offered an alibi witness in State versus Robinette, the 5th District talked about the fact that even an alibi as to the date of the alleged incident relied upon by the appellant does not alter the rule that proof of the offense on or about the date alleged is sufficient. So I think that would definitely militate against the defendant's argument in this case. And if there are no questions for me, I don't have anything further. Thank
You do have your 5 minutes.
I couldn't remember if I reserved that.
Sorry.
Just going off a little bit with the state's contentions, when the victim did testify here, the 95% of her testimony was on this first incident that happened on January 10th. There wasn't detail really hashed out about that second sexual encounter that they had that was after this first date of January 10th. And that, while you have the on or about arguments, and when we really look at this, she was arguing January 10th. outside of that date, the state didn't, I don't think would have been able to meet its burden when it came to Valentine or Stacey Salahutin of really showing this conviction was based off this other incident. In reality, the prosecution and the defense was focused on that January 10th date. And that text message does corroborate some sort of relationship between the two, well ahead of this, over a month ahead. And defendant's statements also make this, defendant admitted to having a sexual relationship with her before this December date. Thank you very much.
Thank you. The court will take the matter under advisement. A written opinion will be prepared and sent to both sides, and you can also check on our website.